Chapter 15 of Criminal Procedure Code 1973, Complaints to Magistrates. We are going to cover from section 200 to 203. Only 4 sections are there in this chapter. Before we begin, let's see what the section says. Section 200, Examination of Complainant. Section 201, Procedure by Magistrate not competent to take cognizance of the case. Section 202, Postponement of issue of process. And section 203, Dismissal of complaint. Some of the students have asked, why are you reading the Bare Act? Well, if you're traveling, if you're waiting for someone, you cannot carry Bare Act everywhere. You can utilize this free time by studying CRPC. So simply check Jai's law classes and the Bare Act is available in English version. Now let's enjoy studying law. Section 200 Examination of Complaint says a magistrate taking cognizance of an offence on complaint shall examine upon oath the complainant and the witnesses present, if any, and the substance of such examination shall be reduced to writing and shall be signed by the complainant and the witnesses and also by the magistrate. So this section is simply informing when a magistrate is taking the cognizance, he shall examine the complainant and the witnesses present, if any. Obviously, when there is no witness, then whose examination will be conducted? And such things will be reduced in writing and be signed by the complainant and the witnesses. Also by the magistrate who is taking the cognizance. Provided that it says that there is a condition to it. When the complaint is made in writing, the magistrate need not examine the complainant and the witnesses. A. If public servant acting or purporting to act in the discharge of his official duty or a court has made the complaint. Or B. If the magistrate makes over the case for inquiry or trial to another magistrate under section 192. Now section 200 further says that the magistrate will not examine the complainant and the witnesses if the complaint has been given in writing by the public servant. Over here, the police who is making a complaint of non-cognizable cases are also considered as public servants. Next is if a court is making a complaint, then also the magistrate does not need to examine the complainant and the witnesses. It further says the magistrate need not examine the complainant and the witnesses if another magistrate under section 192 has sent the case for inquiry or trial purposes. Section 200 has another condition provided further that if the magistrate makes over the case to another magistrate under section 192 after examining the complainant and the witnesses, the later magistrate need not re-examine them. Means if a magistrate has forwarded the case under section 192 which we covered and has already examined the complainant and the witnesses, then the magistrate to whom it is marked will not need to re-examine them. Now the favorite part, how to prepare this chart. Before we draw the chart of section 200, let's see the complaint is defined under section 2D. It says 3 things. 1. Allegation of crime. 2. It is either oral or written. 3. It is against known or unknown persons. Now let's make the chart of section 200. Section 200, first thing it says, examination of the complainant will be done. How it is done? By the magistrate on oath. And how it is examined? First, examine the complainant. Second, examine the witnesses if available. And after that, signed by the complainant, witnesses and the magistrate himself. Now there are 2 exceptions where the complainant and the witnesses will not be examined. 1. If the complainant is public servant, the police or the court. Or if the magistrate who forwarded the case to another magistrate for inquiry and trial under section 192. After examining the complainant and the witnesses, then the magistrate to whom it is forwarded will not re-examine the complainant or the witnesses. Let's check some case laws. Badilal Panchal versus Dattaria. Sorry for my wrong pronunciation. AIR 1960 Supreme Court 1113. In this case, Supreme Court held that this section lays down the preliminary procedure which a magistrate shall follow on receiving a complaint. In Pratap versus State of UP 1991 Criminal Law Journal 1669 ALL. A case was registered on basis of FIR and final report was submitted by the police. Now, in this context, what happened? A protest application was filed by the complainant before the magistrate contending that the final report was filed on unjustifiable grounds. So, what action the magistrate took? Listen carefully. The magistrate rejected the final report and issued summons to the accused. It was held that the accused is not entitled to hearing prior to issue of process. It was further held that the order of magistrate is not illegal on the ground that the procedure under sections 200 and 202 of the CRPC was not followed prior to issue of summons. The case says itself, I don't need to explain it. Gurudas Balkrishna versus Chief Judicial Magistrate Goa, 1994, Criminal Law Journal 444 MAH. This is very interesting. Kind of a landmark case. The applicant filed a complaint on 31st July 1992, but the magistrate has not even recorded the statement for verification of the complaint for several months. It was held that verification under section 200 must be done as soon as practicable. The words at once were deleted from section 200 because the legislature thought it fit that instead of giving a mandate by words which would not be capable of any relaxation, it is better to rely on the discretion of the magistrate. But that does not permit the magistrate to delay the verification for months together. The court ordered the magistrate to record the evidence of the complainant and witnesses, if any, within a week from the date of its order. So the thing to remember from this case is the word at once were deleted from section 200. But that does not mean that the magistrate will take several months. It should be done as soon as possible. Section 201. This is very easy section. Procedure by magistrate not competent to take cognizance of the case. Now this section is explaining us what is the procedure to be done by the magistrate who is not competent to take the cognizance of the case. Means it is beyond his power or he is not competent to take that case. Section 201 says if the complaint is made to a magistrate who is not competent to take the cognizance of the offence, he shall A. If the complaint is in writing, return it for presentation to the proper court with an endorsement to that effect. So first thing what he is doing, if the complaint is in writing, he himself is going to forward that case to the proper court with an endorsement to that effect, means he will mention that a covering letter may be put on it. And second thing what he can do, if the complaint is not in writing, then direct the complainant to the proper court. So he is going to ask the complainant that please go to the other court because you have come to the wrong court. I am not competent to deal with this case. I hope section 201 is clear. Section 202. Postponement of issue of process. Subsection 1 of section 202 says any magistrate on receipt of a complaint of an offence of which he is authorized to take cognizance. Now remember over here what is it said, that he is authorized to take the cognizance, okay, or which has been made over to him under section 192, which means some another magistrate had forwarded a case to him. Now in both cases what he is going to do, may if he thinks fit, and shall in a case where the accused is residing at a place beyond the area in which he exercises his jurisdiction. So over here the condition is that the accused is residing beyond the area of his jurisdiction. So what he can do is postpone the issue of process against the accused. Now he has postponed the process. What he can do, either inquire into the case himself or direct another investigation to be made by a police officer or by such other person as he thinks fit for the purposes of deciding whether or not there is sufficient ground for proceeding. So one thing is important to note over here, the order of the magistrate for investigation is not as per the investigation to be done under section 156 subsection 3, because that investigation is at pre-cognizance stage and that is a complete investigation of the case. In section 202, the order of the magistrate for investigation is post-cognizance stage, which means the investigation has to be done on a particular fact that the magistrate has observed. for deciding whether there is sufficient ground for proceeding or not, provided that, now there is a condition to it, no such direction for investigation shall be made. Now the condition is that the court will not order for investigation if, number 1, A, where it appears to the magistrate that the offence complained of is triable exclusively by the court of session. So one thing is clear, if the complaint is triable by the court of session, the magistrate is not going to order for any kind of investigation. Second, B part, it says where the complaint has not been made by a court unless the complainant and the witnesses present, if any, have been examined on oath under section 200. If the complainant and witnesses has already been examined, they are not to be re-examined and no investigation is required. Now the subsection 2 says, in an inquiry under subsection 1, the magistrate may, if he thinks fit, take evidence of witnesses on oath. So this is only in case when the magistrate conducts an inquiry. Provided that, now there is a condition to it, provided that if it appears to the magistrate that the offence complained of is triable exclusively by the court of session, he shall call upon the complainant to produce all his witnesses and examine them on oath. Now the important thing to note over here is he is only going to examine the complainant and all his witnesses, but the case shall be tried only by the court of session. Next, subsection 3 of section 202. If an investigation under subsection 1 is made by a person not being a police officer, he shall have for that investigation all the powers conferred by this code on an officer in charge of a police station except the power to arrest without warrant. It simply says that if the investigation is to be done by another person who is not a police officer, he is going to have all the power which a police officer has, except one power. Which one is that? That he cannot arrest without warrant. Let's check the object of section 202 of CRPC. 1. To ascertain the facts constituting the offence. 2. To prevent the abuse of process resulting in wastage of time of the court and harassment to the accused. And the third object, to help the magistrate to judge if there is sufficient ground calling for investigation and for proceeding with the case. Section 203. This is the last section of this chapter, dismissal of complaint. It says if after considering the statements on oath, if any, of the complainant and of the witnesses, and the result of the inquiry or investigation, if any, which means if the inquiry or the investigation had been conducted under section 202, and the magistrate is of opinion that there is no sufficient ground for proceedings, he shall dismiss the complaint, and in every such case he shall briefly record his reasons for doing so. See, this section is practically very important. If a magistrate dismiss your complaint, he refuses to proceed with the case, the magistrate shall record the reasons. He is not going to do on his own. As an advocate, you must understand that this does not mean that the accused has been acquitted. No, you can always appeal, and the appeal can be done for the reasons that it was an incomplete record or there was a misinterpretation by the magistrate, but the best reason is the new fact has been introduced.